We are going to call this October 20th regular meeting of the DRB to order. And we'll start by introducing the board members. Just go first. I'm Rob Goodwin. I'm the chair. I'm remotely here. I had to travel out of town abruptly to not be there in person. And Catherine is also remotely, so I'll turn it over to her.
Thanks, Rob. I'm Catherine Burgess, Vice Chair, also remote, although just around the corner, unable to come in tonight with childcare. I will pass it off to another board member. I see Alex is online.
And I'm in person.
Oh, you're in person. Great.
I'm in person, Alex Halas, board member. To my left.
I'm Elvira Dina, new board member. This is my second meeting.
Joe Kiernan, board member.
Bill Jolly, board member.
Mike Miller, I will be staff tonight. And Meredith is here as well. She will be.
Wonderful. Thank you all very much for being here this evening. And can we just get acknowledgement? I can't see that the appellate is in the room.
Yes.
Okay. And we have a representative of the owner or permittee.
Yes.
Wonderful. All right. So Mike is going to do the remote meeting procedures, and then we will get started with our agenda.
Do you have the script? Okay.
Meredith can do that, I guess, too.
This one's going to create feedback.
Alrighty, so sorry for the disjointedness here. Prior meeting ran a little late. Just for people in the room or anybody online who isn't familiar, Meredith Crandall, I am the normally the staff for this, but as the person who issued the permit, the official that issued the permit that's under discussion tonight, I am just doing administrative staff stuff, not the full meeting staff. Okay, so I'm going to share my screen. The stuff on the screen is more for people who might be watching tonight's meeting via Orca Media. And then my spiel is going to be for anybody who's on remotely. So for anyone attending or viewing tonight's meeting via Orca Media, you can participate in the Development Review Board discussion via the Zoom platform through either video or telephone access options. For the full video experience, please type this web link into your browser. Alternatively, you can dial in from any phone using this phone number and then putting in this meeting ID when prompted. If you're trying to get into the meeting and are having problems, you can email either myself at mcrandall@montpelier-vt.org or Mike Miller, mmiller@montpelier-vt.org. And we will be monitoring our emails and be able to get you into the meeting, hopefully. For those attending via Zoom, turning your video on is optional. For everyone attending remotely, please keep your microphone on mute when you are not speaking. This helps reduce background noise. And note that the Zoom chat function should only be used for troubleshooting or logistics questions. Substantive questions or comments about an item on the agenda should be made verbally. If you have one of these questions or comments and wish to speak, please raise your hand. And this is both on remotely or here in the room. And the chair will call on you to speak, or if you're here in the room, to come up to the microphone to speak. And when you do speak or come up to the microphone to do so, please make sure to state your name and address for the record. In the event the public is unable to access tonight's meeting, and people are definitely here in the audience, but if somebody's trying to access remotely and can't get in, then the meeting would need to be continued to a time and place certain. I'll now hand the meeting back over to the chair.
Thank you, Meredith. Okay, can I get a approval of the agenda?
So moved.
Seconded.
A motion by Alex, I believe, second by Joe. All those in favor of approving the agenda, say aye.
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 Aye. The nays? Seeing none, we have an agenda for the meeting. Thank you all very much. Okay, well, obviously, comments from the chair here. We have, two of our chair and our vice chair are remote. So we have a little bit of a logistical exercise this evening to make this meeting run smoothly. So I would just ask everybody with their cooperation and allowing us to do that. I think this can get to be, messy real quick if we have a lot of people talking over each other and going back and forth. It just might not work out at all. So we're here to hear what people have to say that's pertinent to the application. And we're going to hear one person at a time and just wait until you're acknowledged and called upon before you start speaking. And if you feel like you haven't been noticed when you try to speak, just make sure you get the staff's attention and they will, inform us to get you on a list to get in line to speak because we can't necessarily see everything that's going on in the room right now. So I thank you for your patience. And with that, we will move on to our one appeal of an application of the evening, which is 116 Town Hill Road. Process here, we're going to call anybody that is wishing to speak on this application up, or at least to acknowledge that they need to be sworn in. So if you want to be speaking this evening, that would refer to at least probably the owner and the appellant and any member of the public that wishes to provide testimony this evening. We need you to acknowledge that you need to be sworn in. And I will start that. Can't see it all in the room. If staff wants to just acknowledge when folks are ready.
So anybody in the room, if you think you might speak tonight, raise your hand. It may as well be your right hand because that's the hand you're going to have to raise to get sworn in. And reminder for board members that
Do we have a quick list of the names just so we know who's
well, we have the two Jameses.
okay.
I'm sorry, I don't know your name. Christina from him.
Okay. And the gentleman in the back? John Grenier. Okay. And anybody online can turn your video on if you need to wave your hand. Okay. All right. So, Rob, you can move forward with swearing them in.
Thank you. So all those interested in providing testimony in this application, would you please raise your right hand to be sworn in as a witness? Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
All right. Thank you.
Great. So we're gonna have a process here, and it's gonna start with the Director of Planning, Mike, giving a summary of the matter before us, the procedural status of it, and sort of the scope of what we're doing. Then I believe we will have the appellant go first. Does that make sense, Mike? All right. So the appellant can come up to the microphone while Mike gets started doing the summary.
All right, so everybody should have received, good evening, everyone. My name is Mike Miller. I'm the planning director. So this is kind of a unique opportunity. This doesn't happen too often that we get appeals. And in an appeal, what we do at the city is because Meredith is the defendant in the case because she wrote the initial decision that is being appealed. She steps aside and I step in as the planning director to go and staff the meeting. So the staff reports and all the information. So this happens once every couple of years, maybe, that we'll have an appeal, but just so the public understands why I'm up here and Meredith isn't. That's the reason why we have this arranged this way. So that way we can have a fresh set of eyes, look at an issue to make sure that nothing was overlooked and kind of getting a second opinion on things. So this appeal was filed by James Nagel. We will be going through, you'll see in the staff report, the overall background of the application as it came in. We will be making a couple of determinations, one of which is about the appeal itself. We have to make a determination on whether or not it is meets the requirements for an appeal. And there's a recommendation in there about that fact, with one question that needs to be determined about the physical and environmental impact on the person interested. And we'll review that a little bit more detail when we get there. And then for board members, you're probably used to seeing a different arrangement to the staff report. For appeals of this type, I usually organize or try to organize it according to the appeal. So the appeal lays out 7 claims. So unlike an application where you're going to get it more sequential with the bylaws starting at 300 and working your way through, in this case, it's arranged where we talk about the appeal because it has 7 points. We go with 7 questions and we address each question sequentially on our way through. And so I think at this point, unless you want me to go through those in detail, I think I would turn this over to the appellant to review and go over his appeal, why he thinks it's valid, and
Great.
I guess address those issues.
Thank you, Mike. So we'll welcome the appellant up to the table to present details of their case.
There's a quick question while he's getting set up.
Well, it's may not quick.
Can you go to the microphone that way?
Yeah.
Recording secretary will be able to hear the recording.
Okay. Hello, I'm Anthony Irapino, Wilczek Irapino Law Office, and the attorney for the applicants, Frog Hollow. And there's a couple things that were not clear to me from the chair's invitation to the appellant that we need to get squared away, remembering that this is a quasi-judicial hearing that's governed by the rules of evidence, and also that is governed by the statute regarding interested person status. As the staff report indicates, the appellant has not made a demonstration, as is required under the statute, of a particularized, non-speculative physical or environmental impact to him that is based on the criteria reviewed. There are a number of items raised in the appeal that are not criteria reviewed. So I would like clarification, and I can explain what those are, but I'd like the board to clarify before just giving the appellant an open opportunity to talk about his appeal however he wants, that we move stepwise through what the statute requires you to do. First, to get to what are the criteria reviewed? There are multiple references to character of the area. That is not legally speaking a criteria that was reviewed by
the particulars of the questions we will get to. I can check with Rob if he wants to have us review the first step first before or after, because
Mr. Miller, I am going to be addressing.
You're going to address that concern?
Interested.
I think I would invite the appellant to speak to the issue of interested party status. We will pause, the board will discuss. We'll allow some more comments from the owner or you yourself, Anthony. And then we can move on from there, going through the specific issues and if that would suffice.
Very good.
Okay, it makes sense. You just, Rob, just wants, we'll start with the demonstration of impact, and then we'll resolve that, and then we'll have you present your 6 cases afterwards. Thank you.
Thank you for entertaining my appeal. I'm James Nagel. I'm at 227 Leapfrog Hollow in Montpelier. That is across the street and down the hill a bit from the property in question today, which is 116 Town Hill Road. First, I want to thank Meredith Crandall and her staff for putting these materials together for tonight's hearing. They're both detailed and thorough, and I appreciate that. One issue that did come up in the summary was that whether or not I was an interested person. And I can say that I own property at 227 Leapfrog Hollow, which is across the street from 116 Town Hill Road. So I am in the immediate neighborhood since I do live across the street. And I am physically and will be physically and environmentally adversely impacted by the development of this quadplex. It will cause increased traffic created by this particular construction project and the subsequent residents that would be living in this quadplex. In addition, there will be storm runoff from this property. That will increase substantially because of the size of the quadplex and the adjoining parking lot. This water runs over and down Town Hill Road to Blanchard Brook, which runs through my property. When there is stormwater runoff, whether it's contributed by this particular property or others, it creates enormous erosion on my property. Both trees have fallen down in the past and will continue to do so because of the increased additional stormwater, and soil erosion happens on a daily basis whenever it is raining, especially on a day like today. I believe I am an injured party and will be further an injured party while the construction of 116 Town Hill Road commences and continues, and thereafter when the quadplex and its associated parking lot is complete.
All right, Rob, he's turning it back to you.
Okay. Board members have any questions for the appellant to get more information to make a determination on their interested party status for this proceeding?
And we'll also probably want to hear, Rob, from the property owners too, if they want to give any rebuttal testimony to that before or after.
We'll do board questions first, and then we'll go to them. Yep. Yeah, go ahead.
Picking on you. Yep.
Hi, Bill Jolly. I do have a couple questions just for clarification. I was out to visit the site over the weekend. Beautiful day, nice to be out. Took a look at the lot 116. That's Leapfrog, I believe we call it Leapfrog Hollow Road. It seems to be not directly across the street. It seems to be down Town Hill a little bit, maybe, a couple parcels down Town Hill toward town, not directly across. I was curious, how far in is 227? I know that the other road is a complete loop. I think it's the Grandview is a loop that goes around. So 227 could be right on Town Hill. But 227, I think Leapfrog goes straight down. Is that right? How far, just roughly how far down or off Town Hill is 227?
Well, as the staff summary report shows, there's a photograph of my property,
Yes.
which starts at Town Hill Road and
Yes.
goes down a private driveway
Yes.
for about a quarter of a mile until it comes to 16 acres that abuts and has Blanchard Brook going through it.
Okay, a quarter mile roughly is it's being affected. Is a quarter mile down. That's where your home is or your whatever,
My
unit
property.
you live in. Yes, it does. I understand it's more of a right of way in a sense. It looked like it was fairly narrow, just enough.
I actually own that property.
Yes, just enough to carry well, you've granted a right of way to whoever, wants to drive down it, I suppose. But it looks like it's about not much wider than the driveway itself. So, you're saying that water comes across there and affects that road, erodes that road out. It looks like
That's not what I'm saying, sir.
Oh, it isn't. Well, that's what I'm confused as to exactly where the injury is from stormwater. The first thing, stormwater is a tricky business, and just curious exactly where the stormwater effect is that you're considering to be increased threat from the development.
In the last 15 years, my driveway has been washed out because of stormwater twice, where FEMA has had to come in and repair the damage.
Because of 116?
No, because of stormwater on Town Hill Road.
Okay.
What I am saying is the water from 116 contributes to the stormwater that is collected in Blanchard Brook. Blanchard Brook goes down along my property, through my property, and falls trees. It takes sediment and soil away. And this would contribute to that.
Okay, well, thank you. I'm just trying to visualize it, having been out there and actually on the driveway and driven down it and taken a look. I'm having a little trouble visualizing, but that's okay. No, I appreciate your explaining that. You said the other problem was traffic going in and out of 116 would affect your property. Now that would mean it would affect that narrow I'm going to call it a right of way because it seems not much wider than, not even here. It just barely covers the driveway. You're saying that the traffic from downtown Hill would affect your driveway, the right of way that may be, I don't know,
It would
10
affect
feet wide.
the egress on my
It would
driveway.
affect it.
Yes.
I'm just having a trouble understanding how that affects it.
If you have been up at the top of my driveway,
I have.
either leaving or coming,
Yep. Both.
and you're there during school rush hour, I call it, which is in the morning and is also in the afternoon. The traffic is pretty tight, and it'll get much worse with having up to 8 cars coming and going from 116 Town Hill Road. And so I'm affected by trying to be able to go in and out of my driveway. And I feel it's going to be exacerbated by the fact that there'll be at least 8 vehicles coming and going from 116 Town Hill Road.
So you think it'd be bad enough to require some kind of attendant at the intersection, like a policeman?
I don't know.
Oh.
I don't know. I don't
Okay, I'm
know.
just wondering how bad.
Because I don't know how many cars they'll have. It's, again, 116 Town Hill Road is termed a quadplex of 4 3-bedroom houses. So that's enough for family of 4 or 5 or roommates. So I'm assuming there'll be between anywhere from 8, maybe 10, 12 cars on that property.
Wow.
Coming out and going in. And that will affect.
Below your drive.
Yes.
Below your drive.
Yeah. Anytime I want to go into town, that will affect my egress and ingress. Yes.
Okay. All right. No, thank you. I appreciate it. I mean, I've got the visual picture. I just need to understand the details a little bit better. Thank you.
Thank you, Bill, for hitting the major points there. I guess one last question, follow up to you. The building height issue, how does that impact you?
The building height issue
Yes.
does not necessarily affect me directly. However, it does affect the adjoining landowners both across the street and adjacent and behind or north of the property.
You would say that you are, oh, Alex, go ahead.
Oh, Alice, I had her hand up too. I have a question about abutting. So is what Bill called a right of way, I would call a private road.
It is a private road.
So as a private road, is that part of your property parcel?
Yes, it is.
And this is something I really don't know. According to the regs, what happens to a property parcel when it's across the street?
I believe the standing is for a property in the immediate neighborhood. It does not need to be abutting.
Thank you.
Actually, that's a good segue to my question. I was looking carefully at the definition. A person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter. So immediate neighborhood makes sense. It fits. Who can demonstrate a physical or environmental impact. You've spoken to your concerns there, but then there's an and who alleges that the decision or act, if confirmed, will not be in accord with the policies, purposes, and terms of the plan or bylaw of that municipality. So this was the clause that I was interested in exploring, is the and, because by my understanding of this definition, if we're setting out what is an interested person, there would need to be a claim both of physical or environmental impact and a violation of the policies, purposes, and terms, if that's accurate.
Yeah, and that goes to the second half.
Okay.
Mr. Nagel's six or seven
Thank
points
you.
that he has.
Those
So it could be that we can,
Yes,
Turn to
those are
there.
those are the, and who alleges, and he alleges the acts will not be in accord.
okay, thank you.
So,
Right. Joe or Catherine, did you have anything to say? Just checking.
I think it's been covered by the questions from other board members so far. Thanks, Rob.
Yep. And okay, all right. So we will invite the owner or owner's representative up to talk about interested party status as a rebuttal.
Just a couple of quick legal points. One of the, I don't want to have to be doing this, but my client's rights are at stake. And the rules of evidence are informed by the standard. And the standard, once again, is he needs to demonstrate an impact under the criteria reviewed. You let him speak extensively about traffic. This is not a major subdivision. This is not a conditional use. Traffic standard is not one of the standards that is reviewed. And so we need to make sure that the evidence is aligning with the standards reviewed. Those are the rules. That's how your planning commission is chosen to write the zoning. It could have had traffic and safety applicable to this kind of small scale quadplex development. It didn't. So we need to make sure that we're talking about the issues that are actually reviewed under the permit. Same thing about character of the area. That is not an issue that was reviewed by Meredith. This is an appeal from her decision based on the standards she applied. So I do think it makes sense before we have a whole lot of, I'd like everyone to go home on time, and I'd like to keep the hearing limited to the issues that are legally in front of you. So I do think it requires some work for the board for us to discuss what are the actual standards that we're talking about tonight, number one. Number two, I would eventually like to call John Grenier, our engineer, to respond to the stormwater questions, because as board member Jolly pointed out, stormwater is a tricky business, and we have someone with some expertise in that. Number three, on the height piece, I think you will find the applicant or the appellant just conceded there's no direct impact on him. That is the standard. He's not entitled to be here on behalf of his neighbors. If they had a problem with it, they could have filed an appeal within the 15 days. The courts are very clear that if you don't show an impact to you and you talk about an impact to your neighbors, that's too bad. You're not here to talk about that. So we're done with talking about height tonight, legally speaking. I hope the board will agree with that because that's how the law is supposed to work. So there's some initial points that I want to raise, and then I'm happy to answer questions about those or have our engineer come back on the stormwater piece.
Yeah, thank you, Anthony. I think
Actually, what I'd like to do, because the rules of evidence are involved, I'd like you to make a ruling on the traffic question now. I'm sorry that you're shaking your head, board member, but this is how it's supposed to work. And I'm not
Well,
trying to be a jerk
hold on a
about it.
second. Hold on a second, Anthony. Would you hold on one second, Anthony? I can't see what's going on in the room, so I would implore board members to say that, you know, don't have any reactions. They're just going to have a process here. I think the process you laid out, Anthony, you know, makes sense. I want to go through issue by issue, methodically, and I do think that the board has to make decisions on each of these 7 points before we start, you know, discussing them as to whether they're relevant. And so with that, I think I want to make sure we're going through, you know, one bullet point, you know, at a time and not intermixing our, you know, our arguments or our topics. Let's keep it to the, you know, either point 1, point 2, point 3, point 4, point 5, point 6, point 7. And, you know, we may decide, for instance, the height one, that's not going to be a topic that we cover this evening. And we also will give the owner, you know, a time to give a full presentation with their engineer on, you know, on their rebuttal to anything in the staff report and into the seven points holistically. So from what I've heard thus far, board members, let's go through these bullet points 1 through 7. And so point, I'm just gonna kind of throw some suggestions out here. I see an argument from what's been presented that point 1, the quadruplex, the square footage of it. I see how that could, you know, relate to stormwater or, you know, or drainage. We can debate that determination, you know, through discussion. Number 2, the same, I see, you know, potential connection to stormwater drainage, which the appellant sort of talked about. The height limitation, I don't see us having grounds to discuss number 3 tonight based on what's been said. So I would suggest to the board that that's off limits, and you guys can agree or disagree. We can discuss that.
Chair, I would like to discuss the height limitation as affecting stormwater. The height of the roof does make a difference about what type of erosion you can have on the property, along with the force of the water coming off the property.
Okay, thank you. We'll take that under advisement. We'll take that under advisement. Number 4, I see that as being a stormwater, 5 stormwater. And it looks like 6 and 7 relate to traffic. So I put these in categories as you know, 4, if I really think height is on a loan, we can discuss that. 6 and 7 are traffic, and the rest are stormwater. So can we just do a straw poll of board members? Can we remove number 3, the height limitation, from our discussions this evening? Based on what we've heard thus far, I'd like to hear board members' thoughts on that issue. Does that appellant have interested, you know, party status for the height limitation bullet point?
I mean, assuming that we're going to be talking about stormwater later anyway, I don't see how the height specifically factors into this. Any concerns that the appellant has over stormwater can be covered when we talk about those relevant items.
Thank you, Joe.
And I think it's clear that the proposed height is within guidelines, so there's not a question that this would be a violation of
Okay, thank you.
guidelines, by my understanding.
I would like to know how the height was calculated. Apparently there is a apex on this roof that's over 37 feet. And yet they're claiming that the roof height is less than 35.
Yeah, okay. Okay. Well, we'll take that comment. I think the board's going to make a determination here on the interested party status. And we'll keep this moving. So any other board members have any comments on the height? Or can we just agree that sufficient info has not been presented this evening to have that relate to the interested party status of the appellant? Bill.
For me, one is interested party issue, agree. The other side, I think we ought to double check our 35 number or our 37 number. What the code actually is. My understanding it was 40, but we can double check that. Maybe it's different in your area, but I think we ought to make sure we confirm.
So Bill, we have to relate everything here tonight to the interested party of the application. We're not looking at the application as a whole.
Yeah, I'm agreeing with half of it. But it's only relevant if in fact it does violate the height. It's only relevant in that sense. So anyway, however you want to phrase that or take it or pack it in, it's fine.
Okay.
So I'd throw that out.
I mean, it's on the application that the height of the building and the garage is 37 feet and 4 7/16. I think that's over 35.
Yeah, but code may be 40.
I think we're talking here about the scope of the meeting this evening.
That's irrelevant. Yeah. Anyway, just thought
Okay.
I'd stick that in. Legally.
Let's move on, board members. So the question of I mentioned put these into categories. You can object to the way I've categorized these. Please speak up if you do. Just trying to stay methodical and organized here. 6 and 7, I put them to the category as traffic. I guess the appellant can feel free to expand upon your case as to how those impact you if you'd like to.
Excuse me, Mr. Chair.
Yes.
Are you ruling that traffic was a criterion reviewed? Even though this is not a major subdivision or a conditional use?
I'm opening the discussion for board members to discuss how we are going to incorporate or not incorporate traffic into our discussions this evening as it relates to party status.
I see, but I don't understand why these.
Sorry, Anthony, he might be able to hear you. I don't know if the recording secretary can, because there's lots of mics going to Rob.
I understand that, but I heard you to say you're asking the appellant to expand upon his impact. And I need to hear a clear ruling from you that you believe, even though this is not a major subdivision or a conditional use application, what is the board's basis for saying we're talking about traffic here or not in terms of his interested party status and the criteria reviewed? The staff report says it's not a criteria that is reviewed for this type of application. The board has a different view of it. It would be helpful to know what that legal basis is. So on behalf of the applicant, I can respond to that.
Mike.
So I mean, because of how we've done this, there were two options for doing this. We could review, give Mr. Nagel the floor to present his whole case. But if we do his interested person status, then we need to we need to do one way or the other, and you can't have it both ways. Yeah. You can't go through and say, I want a determination first and not let him present why he believes, because remember, this is his appeal. He has the floor to make his case. And in the end, we're going to have to make a decision of the interested person and the points. And it may come back that the board finds he doesn't meet these other requirements, and therefore he's not an interested person at all. But we can't make that determination until he makes his case. So we have to do it one way or the other. And so either we have to just go through and say, he has demonstrated a physical harm, and we're going to hear his case on these other pieces, or we're going to hear the entire case and then start to make a decision afterwards to go through and say, does he have grounds to make these cases? But as an appellant, he has more flexibility than an abutter, or this is his appeal. This is his opportunity.
I understand that, but he doesn't get to define the scope of it. The statute defines the scope of it, and it limits it to the criteria reviewed. It would be very prejudicial to my client and a waste of everybody's time to spend a lot of time talking about traffic, which, as your staff report that you authored indicates,
yes,
is not a criterion that applies to this application.
But he gets an opportunity to make his case why he thinks my case is wrong. And this is his appeal to make that case.
So we're not talking about the actual traffic on the road. He's going to now explain why you're wrong and Meredith was wrong, that traffic studies are required for.
Yes, he's going to have to, he's got a bar to cross.
Perfect.
We've put it out here that goes and says, this is what's going to be here.
Okay. So we're not talking about the actual traffic. We're talking about the regulations. And I expect that's what the discussion will be about. What section of the regulations contradicts the staff report? Just want to make sure we're clear because the invitation was rather open-ended.
So, Mr. Miller, I do have a right to try my case the way I want to try it as an appellate. And you, as the board, have the right to decide the case as you feel that it should be decided. Is that correct?
Yeah, I mean, it's Rob is chairing, but yes,
Yeah. Sorry, Rob.
My understanding would be that you are the appellant. So you have the floor to make your case. And, I'm sure Rob would like us to kind of take this in layers. We're not going to get into cases, we make the arguments, or I've made a few cases of where I think you do and don't meet the requirements in your appeal. And it's your floor to go through and rebut the report to go and show that. If Rob wants, you can move forward.
I think we've had a good discussion thus far. I'd like to have you try your case. I think that the objections thus far have been taken under advisement. The board can consider that duly and do its decision. But I think efficiently, we want to hear you make your case on your points. But I will say that just from what I've heard from the board so far, your building height and your traffic, are not things we're particularly interested in. But drainage may be something that would have a little bit more weight with a serious consideration from the board. But it's your time, your floor to make your case the way you want, and we will stop you if we feel this is going astray. And we will give the owner and applicant due time to may have a rebuttal and submit their evidence after you state your case.
So, Rob, we have then made the determination that the appellant is an interested person.
Let's make a clear determination on that, Joe. I think it's a good question. How would we best do this? I'd love some advice for procedural. We have to vote on this, as an intermediary, or how we want to do this.
Yeah, I think the thought would be on this that, or my suggestion would be that we get more information from, because one of the cases that's being made is that it has to do with demonstrating physical or environmental impact on the person's interest under the criteria reviewed. And so the case that Mr. Moore is making is that if they're not relevant, then they're not under criteria reviewed, and therefore it disqualifies him as an interested person. but at the same time, we won't know that until we get the information. So I think we've got information there, and I think we just need to hear more about the appeal itself. And we will need to make that determination, but I think we have to have, if we find that traffic and the height aren't relevant, then those aren't environmental impacts under the criteria reviewed. And therefore that goes away. So I think we'd be premature about making a decision at this point on interested person. I think we need to hear more from the applicant, the appellant, excuse me.
So we're not making a ruling on the status, but we are allowing the meeting to continue to get more to then make a determination. Is that what you're saying, Mike?
Yeah, I don't think it's black and white enough for us to make the call without at least hearing his claims.
Could I just ask a question then? So he has 7 points here. They're not all different, but let's assume they are. Does he only have to prove that one of them is, gives him interested person status, and then he gets to argue all of them? Or I don't really understand how that works.
Yeah, it's an interesting question. I mean, is it just that once you're in the door, you can argue whatever, or does it go down to this level of elimination of points? This is a relatively new piece of statute, so I have not heard of any, and I'm not an attorney, I have not heard of any case law that has actually been reviewed that kind of gets into that level of detail. So I think we have a certain amount of demonstration. Certainly if he was here with no way of meeting an interested person status, we could acknowledge that at the start. There's enough here to at least continue the review and ask the questions and then make that determination once we have all the evidence in front of us.
Okay.
Thank you. Thanks for the context. Any objection to moving forward and making that determination later?
For the record, I do object to the board considering irrelevant evidence. It makes an impact on the board to hear discussion that's not legally relevant. And it's not my job to come after and defend against information that's legally relevant. And I really feel that you have left the door open here in a way that's not actually helpful to all involved. I wish you'd be clearer. And I will, under the rules of evidence, which are part of your own rules that you have adopted and are required to abide by, if the conversation strays into criteria that were not reviewed or discussion that's not relevant, it will pop up. So you do it however you want, but I have a client here who has tremendous rights at stake and want to make sure that the process respects those rights as is required by the law.
Well, I invite the owner's representative and the owner to just come up and make the objections known to the record, and we'll move along if that's what we need going forward. So
I'm happy to do that again.
well, just as we move along, if he starts straying off, just say you object, so it's on the record on the record, and we'll move forward. Is that okay?
Yep. Do you want me? So you want me to wait and see where things go? Is that right?
Yes.
Okay.
But I would, Rob, just to keep things organized, I'm just trying to avoid having a situation where the attorney is going to talk over the appellant. We need to give the appellant his floor, then give the opportunity for the applicant to rebut.
Okay, that's valid advice. Yes, thank you. All right, the appellant, the floor is yours to state your case on the issues that you put in your appeal.
Thank you, Mr. Goodwin. Again, I'm James Nagel, and I own the property at 227 Leapfrog Hollow, which does abut Town Hill Road. I basically have set my appeal of the 7 claims into 3 areas of concern. First is stormwater and erosion, traffic and parking, and neighborhood character. And I will address each one of these areas individually. Stormwater and erosion. When the previous owner of 116 Town Hill Road attempted to excavate his property back in 2021, he hit a spring, which eroded the dirt walls of the evacuation site and prevented him from building and erecting a foundation. The report, the staff report, states that he abandoned the project at that time. What was happening was water was running off the property from the spring that was excavated and causing icing on Town Hill Road during the winter and water across the road during the fall and spring. Based on the fact that he could not stop the spring from having water run onto Town Hill Road, he subsequently abandoned his one family, 3-bedroom home at that time. This quadplex, during construction and then once developed, does not account for how it will handle the increased stormwater and subsequent erosion onto Town Hill Road and into Blanchard Brook. On heavy rain days such as today, the rainwater on this development will not be retained on the property. In fact, today, while I drove by 116 Town Hill Road at around 4 p.m. today, rainwater was flowing off the property. Now, this is a property that does not have any construction on it as we talk tonight. The water flowed off of 116 Town Hill Road, down the road to the Blanchard Brook culvert. And that water then ran down to my property via Blanchard Brook. That was when there was no construction on the property. The property owner is proposing a quadplex that is 30 feet deep, 40 feet high, and 80 feet wide, along with parking for at least 4 vehicles. And that parking lot's going to be between the quadplex and the town road. These impervious surfaces will increase the type of rainwater that we saw today from leaving that property and ending up on Town Hill Road and into Blanchard Brook. That's going to contribute to the erosion of my property. I have many fallen trees due to stormwater from this brook, and this will just add more water to that problem. In the application for the zoning permit, I did not see adequate strategies to prevent this rainwater from leaving the quadplex area and coming down Town Hill or going across Town Hill. My second concern, traffic and parking. The quadplex will increase traffic at the intersection of Town Hill Road and Main Street. The quadplex is going to have at least 8 vehicles coming and going from that development. And maybe even more, since these 4 units are all 3-bedroom dwellings. They may have residents who are roommates. They may have residents who are family members. The number of vehicles coming and going from the quadplex will create added traffic congestion and delay, especially during, as I said before, school arrival and departure times. It also will affect my ability to leave my driveway during those times. The quadplex also has garages, 4 of them. Which will accommodate 4 cars. It also has parking for 4 cars out in front of the quadplex. If future residents have more than 2 cars, where are they going to park? Are they going to park on Town Hill Road, which does not allow for parking? When they have guests that come to their homes, where are those cars going to park? Again, there's no parking on Town Hill Road. And my final part of my argument is simply this. The city has attempted to rule out neighborhood character as a reason for denial of a zoning permit, especially in the new zoning rules. I know they have been passed by council. I understand the rules. However, this quadplex is out of character from the neighborhood. The neighborhood is mostly 1-family houses, maybe 2 or 3 bedrooms, and it's fairly an aberration, to be quite frankly, to see a 4-unit, 3-bedroom dwelling on this part of Town Hill Road. It's going to be about 6,500 square feet. Again, it's going to be 30 feet deep, 80 feet wide, and 40 feet high. It will be an eyesore.
Mr. Chair, please recognize me.
Yes, Anthony.
I have to say it if you don't. The applicant just explained that he understands that the Planning Commission removed character of the area from the consideration of an application like this. And then he proceeded to give evidence on character of the area. That is the definition of irrelevant evidence.
Mr. Chair, I have to bring this evidence to light if I'm going to make an appeal to the environmental court. Because even though this body cannot rule on equity arguments, the environmental court can. And this out of character of the neighborhood argument is an equity argument that I can present to the environmental court on appeal. And I need to reserve my right to do so by presenting it here in front of your body.
Yes, thank you. I understand that the owner has objections. They're noted, and you will have a full rebuttal time to expand upon those. But we'll continue to hear his complete case.
I'm just going to say that's not how the rule of evidence works. You don't get to let someone testify to things that are legally irrelevant and then make us use our time to rebut them. I appreciate I've made the point. I see you disagree. That's disappointing, but I'll let you continue.
Any board members wish to disagree with my finding on that or discuss it further?
I understand the point being made by Mr. Arapeno. He's concerned that it's going to affect our judgment, which given the last few board meetings is fair. I guess the issue is that it's already been written. It's in the appeal already. He's already stated it. We've all seen it. So at this point, sort of the cat's out of the bag, I would say. And I think we can continue letting the appellant, basically reiterate the 7 points that are in the appeal.
I,
I think Catherine's trying to get on.
Catherine, yes.
yeah, I'm still forming this here, but I think between the appeal and the comments, I think we have, we've heard the case around character of the area, and as we've all discussed, it's this is a permitted use. The zoning regs allow for a fourplex, and character of the area is not, considered a criteria there. So I do think we've heard this. We've heard the statement. We've seen the write-up. So I'd hope we could move forward from here.
Can I ask from the appellant, from my notes, you talked about traffic as your second piece. Do you have a claim that traffic is allowed? We find that traffic is only allowed in conditional use and subdivision. This application is neither conditional use nor subdivision, and therefore it should not be an item under consideration.
I think it should be an item under consideration. And I think it's up to your decision whether or not a traffic study has to be created and looked at. There is going to be more traffic congestion. There will be delay.
But for us, the board to consider it, it has to be in our regulations. And that's why it's in the staff report stating that the traffic is not relevant, because it's only relevant to conditional uses and subdivisions. This is neither a conditional use nor a subdivision, therefore can't be considered.
I understand what you're saying, but
Okay.
again, this is an equity argument. It's not necessarily an argument based on the rules that you promulgated for the zoning commission.
Okay.
Yes, Catherine.
Rob, are we responding to the points or asking questions here? As I had one around traffic.
What would you like to do?
Hey, I'll follow your lead here.
I think that board members can respond if they want. My suggestion would be to allow for the full rebuttal before we get into cross-examination.
Okay, thanks.
So do you want Mr. Nagel to continue?
I believe, I'm just going to sum up right now. I'm almost done.
Okay, finish, please. Thank you.
Oh,
Vector doing a reboot because it got hot, so they're not gone, so they should, there you go.
all right. So to sum up, the application for the quadplex should be denied for the reasons I stated above. The concerns are the quadplex is out of character of the neighborhood. That's my equity argument that I will need to make if this is appealed to the environmental court. There are traffic and parking issues that have not been addressed and that need to be addressed for this application to continue. And there are stormwater and erosion issues that have not been addressed that need to be addressed if this particular petition continues. Thank you for your consideration. I appreciate it.
Thank you very much. Now invite the owner or owner's representatives up to offer a rebuttal.
If needed, feel free to make use of both microphones right now.
Okay, yeah, I might. Plug is what I need because the city council meeting was at 5.
You make it?
There might, Phil, is there one to your right? Is there an outlet?
Oh, there's something here. Yeah, it looks like. Yeah, there's an outlet here.
You want to just hand it over, we can.
Yeah, there's an outlet right here.
Yeah.
You want?
Okay, thank you very much.
Anthony, may I
Yeah.
just do a quick
Yeah,
intro?
gotcha.
Good evening. My name is James Moore. I live on Leapfrog Hollow, just off of Town Hill Road, just up from this property. And appreciate your time here tonight. I appreciate you grappling with the various legal questions and, you know, what is the criteria that you're supposed to be looking at and whatnot. I think, you know, for me, there was kind of like a fundamental question. Has the appellant demonstrated that he's met the standard to be an interested party? And I don't believe he has. I think we'll also offer some professional engineering expertise. But more than that, for me, I think you all have a fantastic staff report in front of you. And the even more foundational question is, was there anything in this permit application that was done incorrectly that should not have you all upholding the permit that was issued by the city? And I think that there were no flaws of material order in this permit as it was issued and as it was reviewed by city staff. And I don't believe that you've been shown anything tonight that says there were any flaws. They're bringing up criteria that aren't up for consideration and saying that, well, that's what I really care about. Well, that's fine. That's not the criteria that the permit was issued under, and that you all are deciding whether or not to uphold that permit or not. So I appreciate your time. I appreciate the opportunity for my counsel and John Grenier from Grenier Engineering. So it's also good to have professional expertise in the chair and professional expertise when developing a project like this. And we've relied heavily on the engineers who know what they're talking about. So I'll turn it over to the two of you.
Thanks, James. So, John, can I have you introduce yourself to the board, please?
Hi, my name is John Grenier. I'm a civil engineer from Waterbury, Vermont. Sorry, Mayor. Thank you. My name is John Grenier. I'm a civil engineer from Waterbury, Vermont. I've been licensed in the state of Vermont for 20+ years. We work all over central Vermont and northern New England, and have extensive experience with stormwater, site design, erosion control in our firm. We do many projects of this size throughout Montpelier as well as central Vermont, and feel like we have a pretty good handle on this project and its importance to the city.
So, John, it's fair to say you're familiar with the application materials?
Yes.
It's also fair to say that you're familiar with the Vermont Montpelier zoning bylaws?
Correct.
Great. I'm going to take you through the appeal points one by one and ask you to share with the board some views on each of those.
Sure.
The first point, how many units are proposed for this development?
4.
And do you know what kind of a use for dwelling unit structure is under the bylaw standards of Montpelier?
I believe it's a minor.
In this district?
I believe so. It has not reached the threshold for a major subdivision or major development.
Okay. And how about permitted or conditional use?
I believe it's a permitted use as stated in the staff report and evidenced by the permit that was issued for this project.
Okay, so a permitted use. And in your experience with the Montpelier regulations, do permitted uses involve a character of the area analysis?
They do not.
Character of the neighborhood analysis. Okay, thank you. I'll go on to the second question then. And this is one that we've heard a lot of discussion about, which is stormwater. before we talk specifically about those issues, can you maybe share with the board a little bit specifically of your expertise around stormwater drainage issues?
Sure. Yeah. I'm licensed in the state of Vermont to design stormwater treatment, collection systems, as well as erosion prevention and sediment control systems. Again, I've worked on this certain area of engineering for 20 plus years, and have much extensive experience with projects of this size and larger.
Okay. And have you visited the site where the project is going to be constructed if approved?
I have. I've walked the entirety of 116 Town Hill Road. I followed the drainage along Town Hill Road that's existing, installed by the city, and followed it to the point where it meets Blanchard Brook.
Thank you. Now, in terms of the impervious cover on this lot.
Excuse me, may I ask a question before you get to it?
Please.
I'm Bill Jolly.
Hi, Bill.
Good to meet you. How much have you calculated to be the increase in runoff? Let's say even during construction is one thing. And then once you're full construction, what have you calculated to be the increase in runoff from the property onto Town Hill or even neighboring properties, or even, let's say, even across the street to the appellant's property? How much?
Well, if I can give you a little explanation and then get to there, is that okay? It'll just take me a second.
The number's fine.
I do not have an increase in runoff calculated because it's basically unmeasurable.
Unmeasurable?
Low.
Oh, it's so low that it's unmeasurable.
Correct. This project, the whole lot is 0.43 acres. We're adding about 6,000 square feet of impervious.
Yeah.
Which is 0.14 acres. In the state of Vermont, you don't need a discharge permit if you do a project smaller than half an acre. So we're way below the state threshold for needing a stormwater discharge permit. Blanchard Brook at the confluence with this drainage coming off Town Hill Road is 450 acres. So our project contributes 0.03% new impervious to the drainage area. So de minimis, barely calculable, effectively zero is how I'd answer your question.
That's what I wanted to hear from you. Thank you.
You're welcome.
Just one question for Mike staff. Do we need to certify him as an expert witness or no?
Are you talking to me? No, I'm sorry.
I'm sorry, Rob. We had a couple people talking at once, Rob.
Yeah. Do we, as far as rules of evidence, I don't know where we fit it. I'm just going to ask the question: do we need to certify him as an expert witness?
I don't know if we need to certify him as an expert.
I will object to his testimony unless he's certified as an expert witness.
So the rules of evidence identify somebody as an expert if by some combination of their education, professional training, and experience, they have a level of competence and understanding of the issues that goes beyond the general public's basic knowledge of the subject matter.
Okay.
I would submit that the decades of experience, the professional licensure that you've heard described qualifies Mr. Grenier as an expert in stormwater management, as well as development of this scale in central Vermont communities generally and in Montpelier specifically.
I think that the chair would accept that. Any members from the board have anything different to say?
No. And I, having asked the question, you can't make up numbers like that.
Okay. Oh, great. Just want to get that out of the way. Thank you.
I completely credible for me. Yeah.
All right. Back to the owners and owners representatives.
Well, I appreciate that because you went to where I was going next before that question. So, Mr. Grenier, you just referenced some numbers and about the very small percentage of impervious surface the development would add to the watershed as a whole. What about to the parcel? What percentage of the parcel would be covered by new impervious surface?
34%, and the allowable in the zoning district is 40%. So we're below the allowable site coverage.
Now, you just said 34%. A different number appears in the staff report. Is there a reason, is there a basis for you differing from the opinion in the staff report?
There's a slight miscalculation in the square footage or acreage of the lot. The official survey and our engineering calculations show that the actual area of the lot is 0.43 acres. As listed on the tax map and on the city parcel data, it's 0.40 acres. So there's just a slight difference in that square footage that allows for that percentage. If we used the smaller size of the lot, we're still below 40. We're about 37.5% or so. Either way, we're below the 40% allowable coverage.
And can you explain, put that 40% and that we're below at 34%? Can you put that in a little context? Why does that number matter?
I believe that's lot coverage is, I guess I don't know exactly what the city's thought process is besides setting 40, but in general, lot coverage is to help control stormwater discharge, erosion, et cetera. It's to leave part of the lot empty for natural grass to grow, trees, et cetera. In this zone, while not in the downtown city where you cover a lot with almost entirely with building and parking lot, and so there's more of a rural feel on Town Hill Road. And so the zoning bylaws control the amount of the lot you can cover with an impervious surface, which is a parking lot, a roof, something of that nature.
Yeah, I'm just going to add a little bit to that. It's not an absolute prohibition on the lot coverage. It's a threshold for when a professional stormwater management plan. Oh no, Meredith. Okay.
Sorry, Anthony, you're mixing up two different things.
Okay.
There's the max coverage, and then there is a stormwater threshold, which is different. It's a different specific number.
Okay.
And that's in the staff report.
Okay. And are you familiar with that number?
I would need to look through the staff report. I don't have it off the top of my head.
Look for it.
For which number are you looking for?
The
impervious cover or the erosion control numbers?
So the maximum coverage limit, and then there's also the, I'm sorry.
Coverage.
Let me ask some other questions. If you turn your attention to page 6 of the staff report.
Page 6.
Yeah.
Okay.
And look at the information in red. So first of all, the staff report indicates that the parcel in question is outside of the combined sewer area. Is that your understanding?
I believe that is correct.
And it also indicates that there is a bright line trigger for when a professional stormwater management plan is required for a lot.
I see
that.
Yeah, I do.
Are you
Thank
familiar
you.
with that?
I am.
Okay. Did you prepare a professional stormwater management plan for this project?
We did not,
Okay. And why didn't you do that?
because we are well below the threshold of 10,000 square feet.
Okay. So you're about 3,500 square feet below. Is that
Yeah,
right?
we're in about 6,500-ish.
Now, that goes to the question of whether the application should be approved or not. But we also have on the table the question of the appellant's interested party status. And one of the issues that he raised was the impact of runoff. And I think you've spoken to that a little bit in terms of the minuscule amount that the surface area contributes. But can you say more about, regardless of the regulations requirement for a professional stormwater plan, can you say more about what considerations you've taken into account for stormwater when it comes to the site?
Yeah, absolutely. And you bring up a good point. Like, there are zoning thresholds for stormwater in the city of Montpelier, and there are state requirements. We are well below either threshold, but it doesn't negate the responsibility of a professional engineer to provide a safe site and a well thought out and a well planned site. In this site, we have the fortunate ability, we are in still of a city feel, and there is infrastructure to control and deliver stormwater safely from a site, whether it's Town Hill Road or the properties along Town Hill Road. On this particular site, we have a really well-defined ditch swale that follows Town Hill Road. There are multiple culvert crossings that are of adequate capacity for the flow. I walked and checked and looked to make sure the ends were open and nothing was buried. And the water crosses Town Hill Road that's in those ditches through a large culvert with a concrete head wall and discharges it into Blanchard Brook. The talk about erosion too, or just stormwater?
Yes, please. Yeah.
Right. So the other effect of the site is some testimony was made about past projects and left open. An abandoned site without proper grading and control of open soil is going to erode. Our project will control erosion during construction. That's the most critical time. You dig the hole for the foundation, you strip off topsoil and get ready to either pave or have a gravel road. You get a rainstorm during that effect, then you can get an erosion. That's when we have silt fence and we have check dams and other features that allow us to control runoff and make sure that it doesn't leave the site during construction. All that erosion control measures stay in place until vegetation has been fully established. Once that's established, you take out those features and use the natural grade, the grade that you've provided in swales that are either reinforced with vegetation or stone to keep the site solid and prevent erosion. Water falls off roofs, hits either impervious cover, stone drip edges, or really strong grass soil at that drip edge. It delivers water safely to ditches along Town Hill Road and is transported from the site. We've thought through the drainage, we've thought through the collection of the water, and we thought through how to prevent erosion both during construction and once the project is completed. And that is evidenced by our erosion control plan and our site grading plan that was issued with our application to the city of Montpelier.
Very good. Anything more you want to say about stormwater, John?
No, I think I've covered it.
Well, I do have one more question. So just for those keeping up, we're kind of moving our way through question 2, but we're segueing to question 3. Now did you hear Mr. Nagel's testimony a moment ago?
I did.
So you heard him testify that he is not directly affected by the height. And when I pointed that out, he did backtrack and try to bootstrap questions about height into the stormwater. So as a qualified expert witness, I'd like to ask you, Mr. Grenier, does the height of this building contribute to the amount of runoff that it sends downstream?
It does not.
Okay. Can you elaborate on that?
Impervious surface is impervious surface. Could water dropped from a higher surface create erosion on raw ground? Maybe. If it wasn't adequately covered or controlled, possibly, but that's a pretty big conjecture. As I've previously stated, this site has been thought through with safe and controlled stormwater conveyance and prevention of erosion.
Okay. Thank you, Mr. Ray. Now, turning to the question of height specifically, and I will remind the board that it is the applicant's legal position that the appellant is not an interested party by his own admission on this criterion. But since that horse has been allowed out of the barn, we're going to try and put a saddle on it. Can you explain, Mr. Grenier, how the height of the building was calculated?
Yes, absolutely. Page 3-4 of the Montpelier regulations give a very good diagram of how you calculate building height.
I think, do you want me to share that?
Yeah, that'd be great. Sure.
indicate that page number and the figure number again you were referencing?
Yep, page 3-4, figure 3-03, illustrated building dimension standards. Chapter 300. And the figure, yeah.
This one you wanted?
Yeah, that's perfect. Don't move a bit.
Okay.
On the figure on the right with the kind of brownish tan colored cut through of a building shows exactly.
Should zoom in.
Yep, shows exactly the situation we have in hand here. A building on a sloping site has different ground elevations on the front and the back of the building. So if you like that Ask AI assistant, can you get that to go away? Yeah, I know. I have the same thing. No, it's fine. So what you do is you take the average or the midpoint of the building between the higher backyard and the lower front yard or whatever you're looking at, and then you measure to the peak of the building. If you do that in our case, that comes to 33 feet. The height requirement or the maximum height requirement in this zone is 35. So we have accurately represented per the zoning diagram and the rules in the municipal standards that our building is below the maximum building height.
And that's called out in the staff.
That's called out in the staff report. It's shown on architectural cut-throughs of the building that were provided with the application. Feels like we've documented it as well as we can and accurately based on how measurements are done in the city of Montpelier.
Thank you. Yeah, thank you, Mike. So question 4 is another question about plans not accounting for the actual development of the 40% impervious surface limitation. And the staff report helpfully says, see response to question 2. And I will say the same thing. Please keep in mind the testimony of Mr. Grenier about those issues, because unless you have anything more to say about that, Mr. Grenier, I believe that was a quite comprehensive assessment of impervious surface and stormwater.
I do not.
And question 5 is about erosion prevention and control. And again, I would say covered that, but one last chance to say anything about that.
No, I'll just rest on the plan we submitted and also the report provided to you by the zoning administrator.
Give me a second, catch up. We're almost at the end of our questions. But my thing keeps jumping around. So just to be clear, are you aware that the zoning regulations require standard across the board erosion prevention, sediment control practices for all development, regardless of the threshold?
I believe that's correct.
Okay. And is it your testimony then that the erosion prevention and sediment control measures that you outlined when you were talking a few moments ago is consistent with the minimum required generally applicable standards for erosion prevention and sediment control?
I would say they'd meet or exceed the minimum.
Okay, meet or exceed, is that what you said?
Correct.
Thank you. Okay, so we're almost there, and I really appreciate everyone's patience. That brings us to question 6 and 7, and I'm just going to go ahead and reiterate a legal argument on this point. The regulations are what they are. They allow you to consider what they allow you to consider, and they have taken some issues off the table because of the Planning Commission, whose role it is and whose authority has been given by the City Council, the elected representatives, and whose decisions are reviewed by the elected representatives after every member of the public gets a chance to comment at the Planning Commission gets to comment again at the city council before the zoning regs are adopted, have set a threshold. And the threshold for traffic study and congestion, the whole question of whether you even get to consider that, whether that is quote unquote a criterion reviewed within the terms of the statute, is one that is foreclosed by the regulations, but I'm going to ask a question about it anyways. John, is this a conditional use permit?
It is not.
Is this a major subdivision?
It is not.
Okay. So we agree with the staff report and the fact that this is not the type of project for which testimony about traffic congestion is relevant, nor a study and measures required. I do want to emphasize one other point at this on this. There is also a pre-existing curb cut here. That was a fully permitted and unappealed curb cut. So under Vermont law, that is a final decision. The fact that this new development is taking advantage of the curb cut is entirely appropriate. They are entitled to rely on a final decision of the DRB that was issued historically. And if somebody had a problem about that decision, they should have appealed it when it was originally made. It's not something you can consider at this point in time. You don't get a second bite at the apple. John, is there anything more that you want to say about your professional review of the standards relative to either the questions the appellant raised or the issues he brought forward to try to demonstrate a physical or environmental impact under the criteria reviewed?
No, I think we've covered everything and support all the decisions and the opinion of the staff report.
Thanks. James, is there anything more you want to say?
Yeah, there's just one thing at the very end of the staff report. When I read through the staff report, I was a little confused. And I reached out to the planning office to ask. It looked like there were a couple options. Well, one, first on the interested party, but then two, either a motion to find in favor of the appellant or a motion to uphold the zoning administrator's permit issuance were kind of the two main options. And I saw that kind of 3008 in red there. I was like, what is that? And what I was informed is that could have just written insert the, insert rationale here rather than naming something, which confused me a little bit. So because I was thrown off by that, I just wanted to raise that as well, that it was kind of like, if you go down that route, then you got to insert the rationale. That's all. And I appreciate your time this evening.
Thank you.
Do we leave or do we have, wait if they have questions? Mr. Chair, do I have an opportunity?
Well,
Yeah. So we'll any board members have any couple questions for the owners or owners representatives?
no questions.
I have a wonky question. Does stay mat count as an impermeable surface?
It does.
Or is it calculated differently than asphalt?
The rate at which runoff leaves it is slightly different, but it's considered an impervious surface.
Thank you.
Yep.
Mr. Chair, can I ask
Yes.
is
You should direct questions to the chair,
Yep.
and not to the applicant.
so in the staff report, and I'm gonna get to, it's page 8. And it has to do with section 3007D. I'm sorry, 3008D, which talks about professional erosion control. And in the report, it says that the construction activities do not trigger a professional erosion control plan. However, there are 13 erosion control practices. And I'd like to ask the witness if he can go through each one of those 13 to state whether or not he has done those practices for this particular project?
Okay.
I can, he can answer that if the board, the chair gives permission to answer that.
Joe has a question.
I mean, these are all things that need to be done during construction, and you just ask if he's done them. He can't do them
If he
until.
Plan to do them.
I'll also state that these are standard practices for just about every project.
Correct.
This is like boilerplate stuff.
Correct. I understand that. And in the report, it says if he doesn't follow these, he will be in violation of his, of the.
That is correct. If he doesn't follow them, he would be in violation, but this is something that would happen in the future. And if he doesn't follow them, that would be when he is in violation. We can't find him in violation of them now.
I understand that, but I wanted to know whether he's planning on doing these things.
Are you planning on doing these things?
Yes. I also had a question about the increase of runoff. Are you saying that, or Chair, can you ask the witness whether or not there is going to be no runoff of this property? Sounded like that was the testimony earlier. I just wanted to hear that again.
Again, I don't think he testified there'd be no runoff. He just testified that the runoff would be extremely minimal when compared to the total drainage area of Blanchard Brook.
Correct.
And
would the runoff be increased based on the impervious surfaces that will be planned and constructed? And would that be more than the runoff that currently exists?
Yes, but if we were to make a ruling
Can I ask the witness that so he can testify?
No, you can't ask the witness that. The chair could ask the witness that, but what you're asking is, will the runoff increase? He did testify that yes, it will increase by a minimal amount, but so would putting a brick in your yard. That would increase the total amount of impervious surface in your yard. So.
And then I would ask, what would be the increase based on the plans for the impervious surfaces that are currently being planned for this particular lot?
But am I correct in understanding that that type of calculation is not required?
It is not required
at
for this application.
time for this
Correct.
application. So
Correct.
it's a question that doesn't need to be answered in this context.
Thank you, Joe and Elvira. I would agree with what you've also stated.
I have no further questions. Thank you.
So Rob, I just want to remind you, we did have one other person that had asked to be able to testify. I just have Christina. Do we have
Yeah, I
her?
recognize any additional people to come up to the microphone one at a time to testify. Just keep in mind about the conversations we've had about the scope of our discussions this evening, and try and stay within that.
Can I ask what the basis for this is? This person finally filed an appeal?
It's my understanding that this is a public meeting and public comment is allowed on the application. I do ask staff to back me up on that.
Quasi judicial proceeding.
And it's quasi judicial. I don't know. The general, we would keep a narrow testimony, and they'd have to demonstrate some status of an abutter or.
Yeah. What would be the basis for that, Mr. Planning Director or Mr. Chair?
Well, I like to default on the side of reason, and that the public has the right to comment within reason as long as it's brief. But if we need to get a professional or a more detailed ruling on that, we can.
It would need to be on point to what's been appealed. We can't take anything new or different. It has to be focused on, you can support the applicant or appellant, but we can't take anything outside of the scope of the appeal. Okay.
Okay.
Yes.
Well, good evening. Thank you for
letting me have a moment. My name is Christina Rohan. I'm a I recently purchased 80 Town Hill Road. And I guess I was very surprised by the fact that this size building was going to be put on the property next door. I knew nothing about it when I purchased the property. Have similar concerns in terms of traffic and parking. And I understand that the character of the neighborhood is not something that you consider, but I do think it impacts that. And it will significantly impact sort of the feel of my property having that large building next door. And I guess I had two questions, if that's all right. I guess one, you're saying I don't have the opportunity. Yeah, that I don't have the opportunity to speak, but I was sent a letter in the mail telling me when this meeting was. So sort of what's the purpose of inviting people to come if we're not allowed to have some comment on what's happening? And then I also had a question about the expert witness in terms of like the expert witness is hired by the person who owns the property next door. And so it feels a little bit biased to have that be the only person commenting on like the water runoff. And I just don't know enough about this process to know how that works with an expert witness, but seemed a little concerning to me that it's the person they brought and that they paid to be here. So
yeah, you're correct that the letter you notice you got invites you to speak on the points of the appeal. As you just did, I think what you just said was seemingly adjoining with the appellant. As far as your second question, the expert witness, the appellant also has the right to bring a engineer, certify as expert witness if that's what they would like to do. This is sort of standard practice in judicial and quasi-judicial proceedings.
Okay.
Yeah, I can comment on that a little bit. I understand there's to be a zoning appeal notice that is posted on the property 15 days ahead of time or whatever it might be, but I believe there is I think it's on the road that maybe it goes up there. It says it's a big red Z.
Yep.
And that'll tell you that there's an appeal process that's going on.
Right.
And when you can attend or how you can get in touch and et cetera, et cetera.
Right.
Yeah.
And I was aware of the timeline for the appeal. I chose not to appeal for a number of reasons. So one, that I'm not in a financial situation to be able to hire a lawyer to come in and help support me, and it's not my expertise.
Yes.
Two, it was said to me that if I were to appeal the process by Mr. Moore, that there would be no opportunity for us to work together in terms of the barrier between the two properties. Felt like I was being put in a position not to appeal. So
okay.
those.
When did you know that was there to let you be aware of what's going on?
Thanks.
Uh-huh.
All right. Thank you.
Thank you very much. Okay, board members, any questions for the owner's representatives or the appellate? Does the appellate have any
You have somebody who's not sworn in who would like an opportunity to comment. They came in late.
Okay, we can swear them in if they would like to speak.
Okay. So if you want to come up, Rob will swear you in.
Hi, my name.
Okay, Rob.
Yep. Okay. So those interested in providing testimony on this application, which is just you, please raise your right hand to be sworn in as a witness. Do you solemnly swear and affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth under pains and penalties of perjury?
Yep.
Could you just state your name and your address?
Samuel Bromley, 45 Easy Street.
Okay. And you heard our talk about the scope. So the points that were mentioned in the appeal.
So I feel like I'm an interested party. My parcel is on the north side of 116 Town Hill. I was the former owner of that piece of property. The owner before me was the individual who dug the hole. I purchased it from them and subsequently filled that hole in and added vegetation to the lot to try to mitigate any stormwater runoff that was there. I owned the piece of property for more than 2 years. And it was never brought to my attention that there was any runoff issues on the lot while I owned it. In terms of parking and well, I sold the lot to James Moore with the understanding that a multiplex building was going to be built there. Both my wife and I were in support of this plan and continue to be in support of this plan. I know that we're not really talking about character of neighborhood, but as a neighbor, I am excited about additional pieces of property and additional housing in our neighborhood. I think those are the pieces that I needed to say. Thank you.
Thank you.
Thank you. Okay.
Would it be possible to add one comment?
Yes, please. So just state your name first.
Yep. Christina Rohan, 80 Town Hill Road. One of the things that was mentioned earlier was just about the curb cut ruling and not appealing that decision previously, but that happened before I purchased my property. So I wasn't in a position to appeal that decision that was made.
Okay.
And I do have concern about the number of vehicles that will be parked there and where excess parking will be if the lot is full, like if guests come.
Okay. Thank you.
I have one thing. So sorry. Sam Bromley, 45 Easy Street. Our neighbors at 80 Town Hill, where Chrissy recently purchased a property from, had a right of way up Chrissy's driveway to the 116 property in preparation for sale of the lot to James Moore. We worked with the owners at the time of 80 Town Hill to remove that right of way, recognizing that James had, or whoever was going to purchase it, had a curb cut. So we were trying to protect our neighbors at that time because they had a right of way on their piece of property, and we wanted to remove that. So whoever purchased that property, that was was not a piece that needed to be factored into the decision. We wanted to make sure that the curb cut was sufficient enough to access that piece of property.
Perfect. Thank you. Just instruct board members that rights of way and the curb cuts aren't really pertinent to this appeal. I think I'll give the appellate any final words, then the board's going to kind of move into discussion mode and next steps.
I do have a question for the owner. And the question is, what did he say to Christina Rohan to intimidate her about not filing an appeal?
I don't find that relevant to this discussion of the board. Board members, you can chime in, but I don't find this topic relevant.
I agree.
I agree.
Thank you.
He said something that prevented her from wanting to appeal. So I'm just putting the question out. Thank you.
So I think James and John, I think we're set here, and thank you for your testimony. And would like to thank the appellant two for his testimony. I think very well organized, and I think the board has, lots of information on both sides here to have a educated discussion about the path forward and or ultimately our options. So yeah, board members, feel free to just chime in your feelings, or if anyone's got a motion, we can go there, but maybe we discuss a little first.
Board members, did the appellant make any claims that the permit was let me see what the real wording here is. Did anyone else see any indication that the zoning administrator improperly applied the requirements of chapter 300 and 320?
Did not.
No, I did not.
Yeah, I didn't either.
No.
And we have a couple of members online. I see Brian Jones and Catherine.
I mean, it's isn't that kind of the end of it then? Or does anyone? Yeah.
The chair would agree with your
also
your proposal there, Joe. Yes.
Sorry, what was that, Rob?
Says I would agree with your statement.
Okay. For the members of the public, though, there were kind of three things that came up here: stormwater, traffic, character of the neighborhood. The appellant was trying to make the case, it seemed to me, that this development would increase stormwater and increase traffic, and his opinion was that it would adversely impact the character of the neighborhood. I think we can safely throw the character of the neighborhood thing out. I mean, that is purely his opinion. Doesn't have to be anyone else's opinion. As far as stormwater and traffic go, he's making the argument that it's going to increase. If we were to deny this application somehow based on that, how would we ever do anything? Every development increases runoff. Every development increases traffic. He makes the argument that he's on Blanchard Brook, drains into Blanchard Brook. Well, Blanchard Brook drains into the Winooski River, which goes out to Lake Champlain. You'd be increasing stormwater runoff to the Winooski River. You're increasing stormwater runoff, into the St. Lawrence River. So at what point does it end? I think for the members of the public, you need to think about these questions, because basically nothing would ever get done, I'd think. And with that said, I am ready to make a motion.
I have to say, I'm ready to make a motion too, but I do want to say that we are limited in what we can do because we are here to review decisions about the zoning regulations. And we can't go beyond that scope, whatever feeling we might have. So the place to talk about zoning regulations according to normative practices is the Planning Commission, who is now reviewing zoning regulations. And if you look back over the history of zoning regulations, you will see Planning Commission after Planning Commission rewriting them and apologizing for previous iterations of the zoning. I mean, I live at the end of a street that was, or near the end of a street that was destroyed by zoning regulations that wanted to increase office space, ironically. And it's now regrettable. But there's nothing that we as a body can do about that.
Catherine.
Yeah, I just like to state support for Joe's commentary, and I appreciate, Joe, that you wanted to set things out for the members of the public that are here, as before we continue to move on with the process. So
all I would do is comment and say maybe in hindsight, maybe we do need better fact finding, maybe more let's not make it quasi legal. Maybe it should have more consideration as to the legal aspects of it, of what we consider, and maybe we should be requiring facts instead of feelings, and the evidence has to prove itself out to us before we make a ruling. And I think that we are so fortunate to have the people we do on this board, particularly Meredith. I'm going to comment on Meredith again, and the fact how thoroughly goes through and stays us within the bounds, keeps us on the playing field. because we could certainly wander off the playing field so quickly if we didn't have the scope and those boundaries there. So maybe we should be taking this into consideration. Traffic is one thing, and in stormwater, like I say, it's tricky. Then there are ways you can deal with that and you can calculate. But maybe we should have and I don't know whether this comes into the planning commission or where it comes to us or where it comes in, but maybe we should be considering more facts instead of feelings, and that they have to prove themselves in this case. Even though those are legitimate concerns, possibly they have to prove themselves. And second, we should be considering the issue of quasi-legal and why is that coming up, again and again. Maybe we need to consider that. So I'm just putting that on the record from Bill Jolly, and this is my first session here, and I'm just observing and commenting on what I see and what I hear. So but I'm in overall certainly in support of what Joe's motion, and the reason for his motion was we have to stay on track, and that keeps us on track and keeps the motion clear with regard to what we need to do. So thanks, Joe.
So we have no motion yet on the table. I'm hearing consensus.
Yeah. Well, I'm in favor of whatever motion.
Catherine, go ahead.
Yeah, I'll add one other point as well that, again, I think I appreciate Meredith and the staff's team thorough work here. I think it's clear what the regs enable a property owner to do. And I think as we're thinking about the values and goals of the regs, a goal here is to encourage housing in a community that really needs housing. So I'm glad to have walked through everything and to have seen the analysis here in the staff report.
Can I bring up one more point? Sorry. It was brought up, almost as a whisper as to how it will affect the value of adjacent properties. And I think is it Martha? No, sorry. You had brought up something about the effect on the value of your property. And I think it may be James was saying the same thing, other people were saying the same thing, that it may degrade the value of the neighborhood property in some way. On the other hand, it may increase it in a certain way. Maybe all of a sudden the average grand list value does go.
Hey, Bill, I just want to stop here. The property values is not something that's in the zoning regs, so we're gonna
out of bounds. But there was something mentioned in the testimony about the value of the property, and maybe we should be bringing that in future, just like the adjudicating legal aspects of it as well. So just a comment for further thought by the board.
Thank you.
So,
great. Well,
Catherine,
I'm happy to make a motion if you're ready for a motion.
I'm ready.
Okay, I'll make a motion that the application met and the zoning administrator properly applied the requirements of chapters 300 and 320, including specifically to the requirements of 3002 dimensional standards, 3008 erosion control, 3009 stormwater management, 3010 vehicle access and circulation, and 3011 parking and loading access.
I'll second.
All right, we have a motion by Catherine. We have a second by Alex. We will now enter into discussion on the proposed motion. Any board members have any debate?
Did she need to include the first sentence there?
Yeah, I got ahead to the details. So that was a motion in upholding the issuance of permit Z 2025-0084.
Thank you.
I think that makes it good, sufficient. All right. Well, yeah, thank everybody for bearing with us. I think this was a good discussion. I think went smoothly, covered a lot of points. I'm just gonna say that yep, stormwater in this city is a big thing we need to take care of. Fortunately, this one parcel is not our solutions to our $1 billion problem here. And I hope we all can work towards fixing that. But that's not why we're here. And I think this motion is great and gladly accepted by the chair. Brian, did you have anything to say?
I would like to support the motion.
All right, thank you.
Have to do because we do have people online.
Yes, roll call vote, always. All right, we're gonna start within the room. Joe Kiernan, how do you vote?
Yes.
Elvira?
Yes.
Yes.
Alex says yes. Bill, how do you vote?
Yes.
Brian, how do you vote?
Yes.
Catherine, how do you vote?
Yes.
And chair votes yes. It's too late for me to count that high, but I think that's unanimous. I know that's unanimous. All right. So the motion is approved. And I want to thank everybody for their participation this evening. Mike, do you have any final instructions to the appellate or owner and the representatives?
No, I don't believe so. We'll be in touch. I'll be working with Meredith to get out the decision when it's ready. And
Yeah, I mean, I just remind them how the decision and the final deliberative decision is what I usually do and give them the timeline, like. Sorry. Yeah. So the board has 45 days to issue the official written decision. The board typically tries to do it much sooner than that. But for both the appellant and the permit holder, you'll be notified when the written decision is ready, because it's a lot easier for you to come and pick it up and sign for it than us to try and mail it certified mail. And all the other people who testified who weren't part of the appellant or the permit holder's team will get mailed copies of the decision.
thank you, Meredith.
Okay, thank you. One final item here. We have to review the minutes from the 10/6/2025 meeting.
Motion to approve.
I'll second.
Motion by Joe, second by Alex. All those in favor say aye.
Aye.
Any nays? Hearing none, the ayes have it. We have minutes approved. All right. Thank you, everybody, again. Next meeting is Monday, November 3rd. There are applications on the agenda, so we need to see you all there. Please let me know if you are not, and staff, if you're not going to be able to make it. We just, need to know this stuff ahead of time. Any board members new or whatever have not completed the ethics training that got sent around, please make sure you do that and reach out to Meredith if you need more information or unsure if you did it.
Thank you, Rob. Motion to adjourn.
Second.
Motion to adjourn. All those in favor say aye.
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 Hi.
Nays? Mike, you have anything further?
Thank you.
Thank you.